miss you day and night. I can't get enough. Oh, nah. I can't lie. I love the way you're messing with my mind. I can't get enough of my sweet Madeline. You're the reason why I'm waking up smiling. Oh, my sweet Madeline. Your name is written all over my heart. I can't stop. Yeah, I wanna be the one to hold you close, 'cause you're the only one I'm dreaming of. My love, my love, my love, my love, my love. Tell me, do you feel the way I do? 'Cause I only wanna ride with you. My love, my love, my love, I wanna ride with you. My love, my love, my love, I wanna ride with you. Yeah. My love, my love, my love. The things you do to me, I can't escape it. The air that I breathe even speaks of you. Yeah. Oh, I can't lie. I love the way you're messing with my mind. I can't get enough of my sweet Madeline. You're the reason why I'm waking up smiling. Oh, my sweet Madeline. Your name is written all over my heart. No, I can't stop. So I'm not giving you up. No, I give you all that I got. Oh, I confess with each beat of my heart. Oh, I'll be true. So I'm not giving you up. No, I'll give you all that I got. Oh, I confess with each beat of my heart. Oh, I promise you. Oh, I wanna be the one to hold you close, 'cause you're the only one I'm dreaming of. My love, my love, my love, my love, my love. Tell me, do you feel the way I do? 'Cause I only wanna ride with you. My love, my love, my love, I wanna ride with you. Yeah. My love, my love, my love, I wanna ride with you. Yeah, yeah. My love, my love, my love, I wanna ride with you. Yeah, yeah. My love, my love, my love, I wanna ride with you. I wanna ride with you, baby. My love, my love, my love, my love.
What up, though? What up, though? What up, though? This your boy Tay-Biz, man. TV is back in the building, man. We are here. We had to go live tonight. Again, you saw the thumbnail. You see the craziness that's going on right now. So we had to talk about it. We had to deep dive into it, and we definitely wanted to go ahead and I was gonna do a video of this. I'm not gonna lie. I was gonna do a video of this, just like do a premiere video, but it's so crazy. It's like we may have to do a little recap in here, revisiting of some things. We may have to, talk about a few things here, because this case with Shawn Mickey Stines, which is a high profile case in Letcher County. We have been following this case specifically on this channel since its conception, since the shooting that happened September the 19th, 2024. That was just last year, y'all. That was just last year. That was towards the end of last year when this happened. But it's so deep, the situation. It's so deep what's going on, that it's not just about the fact that, okay, he shot the judge on camera, all right, in the judge's chambers, okay? If you're not familiar with this particular case, Shawn Mickey Stines was the sheriff of Letcher County, and he has been seen on video camera in the judge's chambers, and he shot the judge, Kevin Mullins, 8 times. Okay? 8 times. And walked away and turned himself in at approximately 3:00 in the afternoon. A Kentucky state trooper by the name of Clayton Stamper is the lead investigator of this case at the time of the shooting. And he was on a hot seat. He's on a hot seat, which is one of the reasons why there is a motion that was filed yesterday concerning grand jury testimony and certain testimony not being recorded. We definitely got to talk about it. The Malabar Ma saying, please hit the like button on your way in. Please do so. It's free. It is free 99. You don't have to pay for it. It is free 99. All right. Go ahead, hit the like button as you come in. Come on and share this video, share this live. We are getting started. We just getting started here. Okay. We are just getting started. We were able to figure out this case, like this whole thing about the motion to dismiss the indictment and a motion for a bond hearing. Both motions were filed yesterday. And guess what? We have them. We have them. Okay. We have the motions. All right. And so we are going to read them. We're going to get into them. We're going to get into an article from the Mountain Eagle with a little bit of detail. It's going to preface the actual article. I mean, the actual motions. And then what we're going to do is we may need to revisit the preliminary hearing. Okay. One of the things that I was looking at, and hopefully everybody's okay, everybody's all right. This is a Thursday night. I know the NBA Finals is about to start at 8:00. They got the countdown. Then 8:30 is tip off. I understand, but I had to go live. I had to go live because the motion to dismiss this indictment is it's a very, very specific thing. And one of the things that we mentioned on this channel is the fact that the indictment is probably the most important piece of any trial. It's what are you being charged with? Because the Commonwealth has to be able to prove that they are able, beyond any reasonable doubt, to prove that you are convicted or you did such crimes or such charges. Remember in the YSL case, in the trial, Brian Steele filed a motion for a mistrial due to a miscategorization of a charge on the indictment. Of course, Schlineville denied the motion. He denied he denied to recuse himself until they had to get some people in. They had to get some procedures involved where he had no choice but to get up out of there. And then Judge Whitaker had to take over. But he got recused. He had to get him up out of there. They had to get him up out of there. You know what I'm saying? And this is one of the things where this might be the case where the indictment is incorrect, and the indictment is not only incorrect, but it's also has some things missing that the jury, the grand jury, the jurors wanted some information from investigators. They wanted they had some questions concerning law enforcement and some things they wanted to investigate. And according to this motion, they did not get any information that would give them the necessary whole picture of what took place when it comes to Shawn Mickey Stines being charged specifically with murder of the first degree. He is not being charged with manslaughter. He is being charged with murder of the first degree, which means in the state of Kentucky, if you are charged with murder of the first degree of any kind, you are susceptible to the death penalty. Okay. So this is a very serious case and trial that's going on. All right. So we're definitely going to deep dive and get into this whole situation. Please go ahead and like, share, subscribe to Taybiz TV. I'm telling you, we are doing some good stuff over here. I'm not the type of channel to like blow you up in your notifications like that. However, because time won't allow me, first of all, but I like to space out a little bit of content every now and again. Sometimes I space out a little bit too much, I've been told, but sometimes when I have the opportunity to go live and to be able to expound on some things, I will do so. And that's one of those things tonight. First of all, before we get too started, man, I want to also shout out my mother. It's her birthday today, so we got some air horns for moms. We got some. She turns 74 years old today. So shout out to moms, man. This is going to always be on Taybiz TV. That's what's up. All right, if you're ready to rock and roll, put a 1 in the chat if you're ready to rock and roll. All right, we about to go ahead and get it popping. Let's go. Yes, sir. Yes, sir. Yes, sir. We are in the building. We're in the building. Oh, that is what's up. Let's go. Lexi, that law nerd, said happy birthday to mom. Shout out to Lexi, that law nerd. She reposted my ex post this today for this particular live. So I appreciate you. So let's go ahead and give her a round of applause for Lex, the law nerd. I appreciate you. That's a sweet name, by the way. That's cool. That's definitely cool. Go ahead and again, share this, like this, subscribe, man. It's gonna be awesome, man. So this is what we're about to do. We're about to go into, first of all, let's go into a quick, just a quick little cap of what we're doing here tonight. All right. The thumbnail is talking about a motion to dismiss the indictment of Shawn Mickey Stines. Again, Shawn Mickey Stines is the sheriff, ex-sheriff of Letcher County, who in the judge's chambers shot him 8 times on camera. Okay. This is one of those cases that you don't hear about all the time. Almost never. First of all, you never really hear about cameras being inside the judge's chambers. Okay. You never really hear about that. And I can't recall a time where a sheriff shot his own judge in his own county, in his own district. I've never heard of this before. Okay. And so one of the things that is connected with this case is a civil lawsuit that was filed January the 31st, 2022 by a young lady named Sabrina Adkins, who was on ankle monitor. She had an ankle. She was supposed to have an ankle monitor. She was on probation. She had been in jail, and she was an inmate of the Letcher County Jail. And a gentleman, ex-Letcher County Sheriff Deputy Ben Fields, decided that with his extra gig, which is being a part of or spearheading the Kentucky Correctional Services Company that service these ankle monitors and things of that nature, he was utilizing these tools for sexual favors. Okay, for sexual favors. Not only was he utilizing this tool for sexual favors, Sabrina Atkins, who filed the lawsuit, also in her deposition, told the investigator and detective in the deposition that she also saw a video of Judge Kevin Mullins doing the same thing. Now, listen, how did they see this video? I mean, they didn't go to no hotel. They didn't go to no motel, hotel, Holiday Inn. No, the man was doing his business in the judge's chambers. At this time, there was no cameras. And so in the judge's chambers is where this particular activity would take place. It's really SA, right? He utilized his power, utilized the fact that she could not afford, Sabrina Atkins could not afford at the time that her ankle monitor, he was soliciting from her these favors. Well, they're called favors, but it's SA. And utilizing his power to gain advantage over her. And so when it was time for her to go to court, he put the ankle monitor on to make it seem like she's doing her bit. She's doing what she's supposed to do. When it was off court, it was free for all. Again, in the judge's chambers. She testified in her deposition that the judge was also doing the same thing. Now, in that same deposition, she mentioned Mickey Stines, because Mickey Stines was on the lawsuit in his official capacity as the sheriff who did not train Ben Fields properly when it comes to utilizing and exercising his I would say law enforcement duties to the inmates who were on probation and things of that nature. Tracy Talks say, yo, hey, y'all, hey. She said, I missed y'all. We miss you too, Tracy. Let's go. Let's shout out Tracy real quick. Let's put a little bomb. Damn. But Tracy Talks in the building. Let's go. Appreciate you coming through. I love our chat, man. Our chat be on point, man. We're a small little family, man. We got like a little cookout. We got like a little cookout family. You know what I'm saying? You know, there was one point where, you know, Cat and I Williams, she used to just bum rush our chat over here, man. It'd be like 200-300 folks up here. You know what I'm saying? But then every now and again, your true ones come through on nights like this where it ain't all overhyped. It's just a subtle. I could really have a conversation. You know what I'm saying? I could really get a chance to talk to you. You feel me? So definitely appreciate you, Tracy Talks, for coming through. And listen, let's get back into it. All right. So Ben Fields, he's connected with this whole case, and so is Shawn Mickey Stines as the sheriff who did not train him properly. So he was also being sued as well. Now Ned Pillersdorf is the attorney for Sabrina Atkins. Now check this out. As that lawsuit was going on, there was another lady by the name of Jennifer Hill who was also utilizing the anchor monitor services from the Kentucky Correctional Service Company that Ben Fields was the president and spearheading everything over, right? Okay. He offered the same thing to her. Same thing, and she refused because she said, my fiance is helping me with this particular ankle monitor price. I don't need to do this. He told her, and this is also in the lawsuit. As a matter of fact, I'm going to pull the lawsuit. I'm going to put the link. I'm going to give you the link right now so you all can read it at your own time. All right. Here it is. Hopefully that works. Okay. If it don't work, let me know. I'll get it a different way. Give it to you a different way. But in this lawsuit, okay, it's also mentioned that about Jennifer Hill. But the woman is unknown in this. I think they always say the second woman, but her name is Jennifer Hill. She passed away, according to reports, she passed away of an overdose around the time that Ben Fields was being heavily investigated, right before he was sentenced to go to jail. Okay. All right. This is what's going on here. Jennifer said, listen, I don't need to do all this sex favor stuff, bro. Like, no, I'm good. I got a man, my man helping me with this, boom, whatever. And even and Ben Fields was so adamant about this. He went to her house. Knocked on the door. The fiance was there and everything. Threatened the fiance, told her when she was there, if you don't do this, I will make sure that whatever happens, it'll say that you died from an overdose. And guess what? That's exactly what happened. That's on record. That is on record of her reporting what he said. Her fiance went to Letcher County to make a report concerning Ben Fields. All of those officers in Letcher County Court pushed him out the court, told him not to say nothing, shut up, don't say nothing. If one of the mods can go to the channel and share the link to the last live we did, and it got the word motive on the thumbnail, we go look at that live. I'm telling you, we did a deep dive on that boy. It's either that one or the one before, but I have the Shawn Mickey Stines playlist on the channel as well. I got to clean up my playlist part of the tab in my channel, so bear with me. I apologize in advance. But this is what's going on here. That's the corruption that's going on here. All right. So because Jennifer Hill, she also again filed charges on this guy. Because Jennifer Hill passed away from an overdose, and we're air quoting, the charges that was related from her to him were dropped. So that's why he only went to jail for a short period of time, or he went to jail for a short period of time at that time, because only Sabrina Atkins' charges was against him. Okay. Yeah, this rabbit hole goes deep. Now, let's go into, because we're going to fast forward a little bit. We're going to go to September the 16th. Why is September the 16th so important? I'm so glad you asked. That is the day that Shawn Mickey Stines went to his deposition. Okay? And he was asked a series of questions. And that is also the time that Shawn Mickey Stines, thank you, Chill. That is also the time that Shawn Mickey Stines was keeping his family up already, leading up to the deposition. Keeping his family up. They was arguing all the time because the man wouldn't let them go to sleep because he was paranoid because of the threats that he was receiving from them. And I'm gonna air quote them, because whoever them is are people that have some type of power. September the 16th, 2024 was the deposition of Shawn Mickey Stines. 3 days later, September the 19th, Shawn Mickey Stines goes to work. As a matter of fact, there was one particular gentleman that he was hanging with that day. His name is Michael Clark, who also worked at the Alcohol Rehabilitation Center Corporation. That's the ARC company, that same company that was being investigated by the IRS and the FBI for Medicaid fraud, up to $130 million. That day, September the 19th, Michael Clark and Shawn Mickey Stines was together delivering food to the community. Okay? When you look at the video of the lead up to the shooting, which again, if you go to the Shawn Mickey Stines playlist here on this channel, you will see all these things. You'll see the body cam footage, the updated footage, you'll see all kind of stuff. You see Michael Clark in that room with the judge. The judge is smoking a cigarette with the window open, everybody chilling. It's a young lady sitting on the ledge. Michael Clark is hanging up. He over there chilling by the library, by the little library shelf or whatever. Everybody cooling. Why? Why are they so relaxed? Because they had just came from lunch. They just came from lunch. And at this particular lunch, a conversation was brewing, and it was brewing so heavy, the judge, Kevin Mullins, said, "Hey, Shawn, Mickey, do we need to talk about this in my chambers?" Again, it's all video, no audio. So you don't know what the conversation was about. At a certain point in that video, Shawn Mickey Stines tells everybody to get the stepping, like Martin used to do to Pam on Martin. Get the stepping, right? Gina, baby. Yeah, get out. This conversation gets heated fast. So fast to the point where at a certain point, Shawn Mickey Stines is trying to call his daughter, his wife, multiple times, both of them. He's not getting an answer at all. Then all of a sudden, his auntie FaceTimes him. And you see a little small snippet of a lady in the corner of his phone, and that's a FaceTime. That was a call that he wasn't expecting. Rushed off the phone with her, and then he asked the judge for his phone. The judge gave him the phone. You see the exchange in the video. And when Mickey Stines calls his daughter on the judge's phone, he brings the phone to his ear like this here. All right. And he's talking for a little bit. He hangs up. He tosses or throws the phone towards the judge. He gets up. Abruptly. Once he gets up, he pulls his shirt over under his holster. He pulls his weapon out. He goes towards the judge. The judge at first was chilling, and all of a sudden his hands is up, like, yo, what's going on? Okay. Then you see Mickey Stines because the judge was trying to get up. Mickey Stines tells him to sit down. Then he locks the door. Then instead of being so close to him, he pulls back a little bit. He points the gun towards him. Whatever he's saying, Mullins is like, yo, yo, yo. And then he begins to shoot Mullins. Mullins go under the table and everything. He goes on both sides to make sure he is not here. He shoots the man 8 times, y'all. Opens the door, walks out, go past another door. There's a hallway after that door, goes down the hallway, and again, turns himself in around 3 o'clock. Now, there was an arraignment. The arraignment of Shawn Mickey Stines, he said, I'm not guilty at all. I'm not guilty. He pleading, I'm not guilty. Then he's pleading insanity. That's his defense. Now, in the preliminary hearing, which we need to revisit. We're going to revisit it tonight. Okay, we're going to revisit it tonight. We're going to see it tonight because this preliminary hearing, in between that time of the preliminary hearing and the grand jury meetings for the grand jury, in between that time, there's something happens according to this motion. There is an alleged secret meeting, a secret testimony of the lead investigator, Clayton Stamper, okay, with the Commonwealth, and the defendants are not present. Why is that important? That is important because in the state of Kentucky, grand jury meetings must be recorded. Let's see. So, right here in Kentucky, it is required for the Commonwealth's attorney to record all testimony presented to a grand jury. Here's why. Kentucky rules of criminal procedure. You're going to see this in the motion. Rule 516 mandates this recording. The purpose of this requirement is to ensure a record of the testimony is available. Failure to make a record can be grounds for dismissing the indictment unless the Commonwealth can demonstrate good cause for the failure, such as a mechanical failure of the recording device. The recordings must include the testimony of all witnesses. Okay, we'll stop this for a second. The Commonwealth's attorney is responsible for retaining the recordings or transcripts. Another one of the rules, good cause for failure to record. Failure to record can lead to dismissal of the indictment unless the Commonwealth can demonstrate good cause. Secrecy and disclosure. While the proceedings are generally kept secret, there are exceptions, including the right of a person indicted to access the records as described above. Any person indicted by the grand jury has the right to procure a transcript or duplicate of any recording related to their indictment. So basically, they're accusing you of violating a constitutional and a right through the statutes of Kentucky. This particular meeting was not recorded. However, how did they know about it? How did they know about it? That's my question. How did Jeremy Bartley, the defense attorney, know about this meeting? Well, there was a motion by Ned Pillersdorf last year where he wanted or subpoenaed the attorney general for more discovery information, because the attorney general gave Ned Pillersdorf redacted information concerning his civil lawsuit that he had with Sabrina Atkins. Ned Pillersdorf submitted a subpoena to retrieve the unredacted version of these documents. And there was a man by the name of Edward Atkins, 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 who was the judge at the time. The attorney general gave and filed a motion to quash the subpoena, and the man granted it. So this is the reason why Jeremy Bartley recently also joint filed with Ned Pillersdorf about getting more discovery time. And also they wanted to give Mickey Stines another deposition. This is like last week, because his deposition that he did last year, September the 16th, 2024, was under pressure and threat. Now we are here. I hope I set this up right for you guys. Now we are here. This is the reason why we are here now. We are here because of this.
And we're now following breaking news out of Letcher County. Attorneys for former Sheriff Shawn "Mickey" Stines have filed a motion to dismiss his indictment.
Stines is charged with killing Letcher County Judge Kevin Mullins. Attorneys for Stines say the grand jury was not given information by the Commonwealth. Attorneys also say there was an intentional failure to record proceedings in front of the Letcher County grand jury. Stines was indicted back in November. Attorneys also filed a motion for a bond hearing. That filing says no bond has been set, but attorneys are asking for that hearing to be set once Stines completes his mental evaluation, which is set for this month.
That's where we at. Set for this month, a mental reevaluation. We talked about that in our last live, I believe, or the live before. We talked about a lot of this stuff, man. And so there is a request by the defense to have this mental reevaluation. And I believe the judge granted it and said, okay, it's cool. Now, look at Tracy. Look at Tracy. Yeah, we in it now. We in it now. We in it. See, it's starting to heat up. You can tell when trials are starting to like really get closer, or something is happening. Something's going on, okay? Because this goes deeper than just the sheriff shooting the judge. This is unheard of. This is not something you hear all the time. Okay? This is not something you hear all the time. Let's go into I want to go into this article real quick here from the Mountain Eagle. And let me tell you something. Let me tell you how committed I am to this, y'all. The Mountain Eagle is a local news article, both online and brick and mortar, right? And I have subscribed for a whole year to this article. Real talk. I have a full login. So I be getting all kind of stuff about Kentucky. And let me tell you something. One of the things that I have seen, and I have did a deep dive into this newspaper article, online report, online news. It is so many missing persons reports in Kentucky. It's not even funny. And a lot of it starts right around Whitesburg, Letcher County area. That's exactly where all this took place. Something is going on down there. One day soon, I'm going to make a video and I'm going to deep dive into the ARC company, ARC, Alcohol Rehabilitation Corporation or company. Medicaid fraud up to $130 million. And I will be mentioning some names, and those names are connected to Letcher County. As a matter of fact, that's where ARC started. It was one place that they was housing people and taking care of them that was on drugs, alcohol, whatever like that, and all that. And then now they have places all over the country, including Utah, but mainly down there in Kentucky. Okay. We're gonna deep dive into that for sure. I have to build this because it goes into a place because I already mentioned one of the names, Michael Clark, the guy who was in the chambers at the time of September the 19th. He is connected with ARC. Oh, we're gonna talk about this. I gotta do it because it's getting heated. Okay. So let's get into this article real quick. All right. So, says defense wants judge to drop murder charge against ex-sheriff. Defense attorneys for former Sheriff Shawn Mickey Stines have filed a motion asking for the murder indictment against him to be dismissed. The motion is one of the two filed in the case today. This is yesterday. You see that? That's January the 4th, yesterday. This is fresh out the grease. The other asks that bond be set at an amount that would allow Stines to meet that bond and return home. That's very specific. In the motion to dismiss the indictment, the defense attorneys, Jeremy and Carrie Bartley, husband and wife, and James Cox argue that there was another meeting between Special Prosecutor Jackie Steele and the grand jury before the murder indictment was returned, and that the meeting was not recorded. It was not recorded. The law requires grand jury testimony to be recorded, but the prosecution has said that there was no testimony at the first meeting, only a request for grand jury subpoenas for witnesses. The defense claims in the motion that grand jurors in the recorded session asked about a civil case in which Stines was a defendant in his official capacity. We are that is specifically talking about the Sabrina Atkins case, the Ben Fields case. It is all connected. But were redirected to deprive the grand jury of its independent investigation. That's a quote from the motion that we will read next. The attorneys are asking for an evidentiary hearing and dismissal of the indictment. The Commonwealth has not yet filed a response to the motion. In the second motion filed today, the defense asks that Stines be granted a bond hearing following the psychiatric examination scheduled for later this month. They say Stines is entitled to bond because the indictment alone contains no proof that guilt is evident or the presumption of guilt is great. Special Letcher Circuit Judge Christopher Caron, who presides over court in the 8th Circuit in Warren County, has indicated he will travel to Letcher for any bond hearing held in the case. Stines is charged with murdering Letcher District Judge Kevin R. Mullins in his chambers on September 19th, 2024. The shooting was captured on a security camera in Mullins' office, and then the Mount Eagle said they would have more information. Okay, so this is the thing. So why is it that they're talking about this? Like, obviously, we all saw that he shot the judge, right? I mean, we all saw that, right? Right? We all saw Mickey Stein tell everybody to get out and then call his daughter, call his wife, all that. We saw the whole thing. What do you mean there's no evidence? Nothing great? What do you mean? Oh, I think I know what he means. He means, according to the charge that the Commonwealth have set in this indictment of murder to the first degree. What is murder to the first degree specifically? It is premeditated murder. They're saying there is no evidence of premeditated murder according to this indictment, and you violated RCR 516, Rule 516. The question is that substantial enough for a judge to dismiss the indictment, just the indictment, and to actually have a bond hearing? This is very interesting to me. This entire case is interesting. Go ahead, please like, share, subscribe to the channel. This your boy Tay Biz TV, man. We are here. We're in the building. If you're watching this, share this. Share this on your social media. Share with your friends. Hey, girl, listen, we got this guy on YouTube talking about some judge getting shot by the sheriff. I mean, you do your thing. Do your thing. Put it on X. Put it on whatever. This is absolutely diabolical, what's happening right now, okay? Again, we are definitely going to get into the preliminary hearing because we need to revisit that. It's very important. It's very important because the preliminary hearing has the lead investigator on the stand. Then when the grand jury meeting or the meeting before the grand jury happens in November, from the preliminary hearing to November, stuff changes. All of a sudden, things are not exactly the way it went in the preliminary hearing. And I wonder why. Let's get into the motion real quick here. All right. This is the motion to dismiss the indictment. Commonwealth versus Mickey Stines. You can't see it because it's cut off, but right there, there's the actual file number, the case number here, and then right there it says 64225. But it's at the halfway point. So it cuts off, but it's right there. Fresh out the frying pan. All right. It says, come now, the defendant, Mickey Stines, by and through undersigned counsel, pursuant to the 5th and 14th Amendments to the U.S. Constitution and Section 11 of Kentucky Constitution, and Commonwealth versus Baker, which is a case law that he's going to reference because it's related to this particular motion in this case, hereby respectfully moves this court to dismiss the indictment in this case. Specifically, defendant believes that dismissal is mandatory under RCR 516, which we just expounded upon, given the intentional failure of the Commonwealth to record proceedings in front of the Letcher County grand jury. Additionally, the grand jury was deprived of information known to the Commonwealth, sought in questions by grand jurors, but not disclosed. So here are the facts. On November 21st, 2024, Kentucky State Police Detective Clayton Stamper testified before the Letcher County grand jury seeking a murder indictment against Shawn Mickey Stines. There was a prior meeting between the Commonwealth and that grand jury regarding Mr. Stines that was not recorded. At the recorded meeting, and Jeremy Bartley is using some very assertive wording here. Grand jurors sought information as to the relation between the case sub judice, which means just before under a judge or before a judge, and the companion federal civil case, but were deprived of the information. Testimony in response to questions asked by the grand jurors was frequently redirected to deprive the grand jury of its independent investigation. The Letcher County grand jury returned an indictment charging one count of murder. Now, here's the law. There was a meeting that wasn't recorded. All right. 516 says what? Commonwealth shall cause, the attorney for the Commonwealth shall cause all the testimony before the grand jury to be recorded, period, point blank. For this purpose, the attorney for the Commonwealth may appoint a stenographer to take in shorthand the testimony of witnesses, or may cause the testimony to be taken by a recording device. But the record so made shall include the testimony of all witnesses, the shorthand notes or the recordings and transcripts of the same, if any, shall be delivered and retained by the attorney for the Commonwealth. This is what the defense need. They need all this information. They need this. They need these transcripts. Like just like in the Karen Reed case right now. Hank Brennan, who is the prosecutor, has all the transcripts from the last trial. And that's including grand jury stuff, everything, all of it. They have all this information. Failure to have a record made, if required by paragraph of this Rule 516, shall be grounds for dismissal of the indictment unless the Commonwealth can show a good cause. What's that good cause? Mechanical failure of the recording device would constitute as a good cause. Now, I'm not sure about nowadays because we have so much advanced technology. You bet not have a bad recording device. Otherwise, you've been living under a rock for some reason. The stenographer or operator of the recording device and any typist who transcribes the stenographer's notes or recordings shall be sworn by the court not to disclose any testimony or the names of any witnesses except to the attorney for the Commonwealth or when testifying in court, and except that any person indicted by the grand jury shall have a right to procure transcript, which is something that we just read. You are being indicted. You have the right to that transcript. You have the right to figure out what happened while you wasn't there. You have every right to do that. In the recorded session of the grand jury provided to the defendant, a grand juror references a prior meeting. Okay. In a recorded session. Oh, there was a recorded session where somebody slipped up and said,
Let him cook now. Let him cook.
wow, this is crazy. A grand juror references a prior meeting with the Commonwealth. Defendant requested from the Attorney General's office a copy of the prior meeting. The Commonwealth responded that the prior meeting was attended by the Commonwealth, but that it was only for the purpose of obtaining grand jury subpoenas. What? For the case. And there was no testimony. That's what the Commonwealth is claiming. There was no testimony. First, the Commonwealth may seek subpoenas to a grand jury hearing without necessity of the grand jury intervening. Thus, it is curious what would necessitate the involvement of this independent body. Second, if a subpoena was sought from the grand jury, then information must have been presented to the jurors. While the Commonwealth may classify that information as something other than testimony, quote unquote, it clearly related to the nature of the investigation. Regardless of how it is labeled or whether it was sworn or unsworn, the information provided to the grand jury constitutes testimony. And should have been recorded. There was no mechanical failure. So the Commonwealth chose to not. The Commonwealth chose. Look at this. That's assertive. You are now blaming them. The Commonwealth chose to not record its meeting with the grand jury. B, the grand jury was denied information sought. The grand jury's functional independence from the judicial branch is evident both in the scope of its power to investigate criminal wrongdoing and in the manner in which the power is exercised. The Commonwealth's attorney does not control the grand jury. The Commonwealth's attorney is the person with primary responsibility for presenting evidence to the grand jury concerning alleged criminal violations. However, the grand jurors may choose to hear no more evidence than that which suffices to convince them that an indictment is warranted, and may exclude the Commonwealth's attorney while they question witnesses themselves. The Commonwealth's attorney may not be present while the grand jury is deliberating or voting on an indictment. And though the Commonwealth's attorney is required to draft indictments upon request of the grand jury, the Commonwealth's attorney does not sign the indictment. The indictments are signed not to the Commonwealth's attorney, but to the court. And this is a lot of case law reference and rule reference here as well. Nothing in our Constitution, statutes, or rules classifies the grand jury as an arm of the Commonwealth attorney. In other words, the grand jury is supposed to be an extension of the Commonwealth, all right? Like, they're not supposed to be in your back pocket. I get it. The grand jury is an investigative body acting independently of either prosecuting attorney or judge. The hallmark of the grand jury is its independence from outside influence. It serves the invaluable function in our society and standing between the accuser and the accused, whether the latter be an individual, minor group, or other, to determine whether a charge is founded upon reason and was dictated by an intimidating power or by malice or personal ill will. An indictment returned by a legally constituted and unbiased grand jury, if valid on its face, is enough to call for trial of the charge on the merits. However, dismissal of an indictment by a trial court is appropriate if it is established that a violation substantially influenced the grand jury's decision to indict, or if there is grave doubt that the decision to indict was free from the substantial influence of such violations. A court may dismiss an indictment where a prosecutor knowingly or intentionally presents misleading testimony. Look at these words to the grand jury that results in an actual prejudice to the defendant. So basically, this is a motion to dismiss indictment because of prejudice, it seems. Commonwealth versus Baker, a detective testified at a grand jury proceedings that the defendant struck her children with an aluminum baseball bat, while in reality, the allegation was that a stick was used for the same purposes. After holding an evidentiary hearing, the trial court dismissed the indictment with prejudice, noting the legal obligation of prosecutors to observe the independent status of the grand jury. He has case law to back this up, solid case law too. The court found that the detective's testimony was material and affected the grand jury's decision to indict. The court also found that the Commonwealth's attorney had knowingly or recklessly elicited the incorrect testimony and that the detective voluntarily testified even though he had no personal knowledge of the facts of the case. Hence, your boy Stamper. Yo, your boy Bartley going in on this motion for real. On appeal, the Court of Appeals concurred that this deprived the grand jury of its ability to exercise its independent judgment. And that in the case at bar, the Commonwealth elicited and Detective Clayton Stamper testified to multiple misleading statements before the Letcher County grand jury. This testimony prejudiced Mr. Stines and resulted in an indictment of murder. The case was presented to the grand jury approximately 2 months after the defendant's arrest and preliminary hearing. The detective and the attorney general's office had ample opportunity to investigate and review evidence, including witness statements before presentation to the grand jury. Now, we definitely need to look at this. We definitely need to look at and revisit this preliminary hearing, because I want you all to listen to a line of questioning that Jeremy Bartley does on cross when, after the prosecution, the Commonwealth, presents the evidence that they discussed, which is the video and the actual action that took place. So this is going to be very, very important, very, very important to this motion. Okay. The detective investigate, review evidence, including witness statements before a presentation to the grand jury. Further, the Attorney General's office conducted the investigation into Detective Ben Fields. This is all connected. This investigation, the resulting charges, and companion civil case are central to the facts of the case sub judice. Unlike the testifying officer in Baker, Detective Stamper is the lead investigator in this case. This case is even more explicit than Baker because the court does not have to infer what facts were important to the grand jury. The grand jurors asked questions and were prevented from hearing complete answers. Had the Commonwealth presented complete and accurate testimony to the grand jury, the decision to charge, or at least the choice of appropriate charge, would likely have been different. In other words, you should have used manslaughter and not first-degree murder. Approximately 12 of the 25 minutes of the hearing was consumed by grand juror questions. It is evident that despite seeing a portion of the video evidence, the grand jury sought additional information to make their decision whether to indict and upon what charge. The indictment is very, very important. Despite the grand jury's specific inquiry, known information as to allegations made during the civil case were withheld. The grand jury also sought mental health information that was not disclosed. And the officer was permitted to testify that defendant was in his sane mind, quote, at the time of the alleged shooting. And what the defense is saying is that this is not sane. He was insane. The detective was also permitted, in contravention of the Fifth Amendment, to comment multiple times on defendant's failure to speak with law enforcement. The defendant respectfully requests an evidentiary hearing to present specific testimony and evidence relevant to the foregoing matters, and asserts that such evidence will establish that Letcher County grand jury was deprived of material information. This deprivation, the defendant contends, warrants dismissal of the indictment. Wherefore, the defendant respectfully requests that this honorable court grant an evidentiary hearing, find that Letcher County grand jury was deprived of material information necessary to its deliberations, conclude that such deprivations undermine the integrity of the grand jury process, and dismiss the indictment with prejudice, or grant such other and further relief as this court deems just and proper. And then you have the attorney's signature. Okay. Another motion. Motion for bond hearing. All right. Mickey Stines, by and through counsel, Jeremy and Carrie Bartley and James Cox, respectfully moves this court to set an adversarial bond hearing pursuant to the mandates of KRS Chapter 431, RCR 402, 4.4, and Section 16 and 17 of the Kentucky Constitution and the 8th Amendment of the U.S. Constitution as grounds for this motion. Defendant states as follows. November 21st, 2024, grand jury returned an indictment against Mickey Stines, charging him with 1 count of aggravated murder. No bond was set. November the 25th, Stines was arraigned, and then presiding Judge Adams declined to set a bond, leaving same for the special judge yet to be assigned. So the special judge is Christopher Caron. As of June 2025, a bond has not been set has not been set. Mickey Stines has given notice of his intent to introduce a mental health defense at trial. Mr. Stines was ordered to undergo a mental health evaluation by KCPC. Same is set for June 2025. The word bailable in Kentucky Constitution 16 has been interpreted to mean that, at least initially, all prisoners are entitled to bond. The right to bail is a constitutional right guaranteed to every prisoner as defined in that section of the Constitution. At the time of the indictment and prior to the entry of any proof, all prisoners who request bail, including those charged with capital offenses, are entitled to bail. This entitlement is based on the presumption of innocence. Presumption. You are innocent until proven guilty. And the practical reality that the indictment alone contains no proof that guilt is evident or the presumption of guilt is great. The indictment does not furnish proof of his guilt that is evident. And in fact, it furnishes no proof of his guilt upon which the circuit court may act in allowing or denying bail. Neither does the indictment create a presumption of guilt, which is great. Now, this is the presumption of guilt towards that particular charge of first-degree murder or aggravated murder. Remember, he's claiming that they are charging him with the wrong charge because of this particular prior meeting that got mentioned in the recorded session. Now he's saying, because you have charged us with the wrong charge, you should dismiss the indictment and my man should not be in jail anymore. Look, even though we have seen this on video, the world have seen this on video. This is the word, this is lawyer talk for sure. To overcome the presumption of innocence and the lack of proof in the indictment, the Commonwealth then has the opportunity to demonstrate that proof of guilt is evident or the presumption of guilt is great. The trial court is vested with sound discretion in considering whether the Commonwealth has met this burden. If the court determines that bail is available, KRS 431.525 mandates that it must consider the following in setting an appropriate bail. Bail is sufficient to ensure compliance with the conditions of release set by the court. Bail is not oppressive. Bail is commensurate with the nature of the offense charge. Bail is considerate of the past criminal acts of defendant. Bail is considerate of reasonably anticipating conduct of the defendant if released. That's big. Bail is considerate of the financial ability of the defendant. The defendant in this case is charged with a single count of aggravated murder. Prior to his arrest, Mickey Stines had an exemplary record with a complete lack of criminality or deviance. Mr. Stines has served in law enforcement capacity his entire adult life and was actively serving as sheriff of Letcher County, Kentucky, when he was arrested. He was arrested in his official capacity. Okay. Upon his arrest, pretrial services completed a risk assessment, scoring Mr. Stines as an FTA risk low, flight risk no flight risk. NCA risk low, 0. Mr. Stines has been a lifelong resident of Letcher County, Kentucky. He's been a good old boy. He got wife, kids, he got grandkids, a host of friends that staunchly support this man. Considering Mr. Stines' strong ties to the community, lack of criminal record, and family support, it is apparent that Mr. Stines would be compliant with any conditions set by this court. Wherefore, the defendant respectfully requests that this honorable court has an adversarial bond hearing at the court's convenience, but following completion of the KCPC evaluation scheduled for June 2025. All right. Now, this is crazy, man. Tracy Talk says this is pretty clear and straightforward. Wow, I'm gonna need to see the Commonwealth response, please, sir. Yes, they haven't responded yet. When they do respond, we're definitely going to get up in there. Okay, we're definitely going to do that. All right. This is again another again, when you have a lawyer that know how to piece it together, like how Brand still did Young Thug, like they just know how to piece it together. So basically, because you screwed up the indictment, you had this prior meeting that should have been recorded, and you didn't record it. So you charged my client with the wrong charge. It should have been voluntary manslaughter or involuntary manslaughter, one of the two, because this was a heat of passion offense. It wasn't a premeditated offense. And on top of that, he has a right to set a bond or to have bail. You denied him this right. So you just violating everything. And so we going to call you out on it. That's basically what Jeremy Bartley is doing. Interesting part of this particular motion with the indictment is the fact that he mentioned that Stamper, who is a Kentucky state trooper, he's a Kentucky state trooper. He was the lead investigator of what happened, okay, on that daunting day of September the 19th, 2024. Shout out to Abundance. Shout out to Abundance. What up, though? She said, what up, though, Biz Nation? Abundance, I appreciate you coming through. Another mod that loves to be dropping by and showing support and love to your boy. I definitely appreciate you. I'm going to go ahead and give you the same applause. Same applause. And she be rocking out on the Mailroom Network, too. You be rocking out on it. You be coming through the Mailroom Network, too. Like, I appreciate you for real. I appreciate you for real. All right, because that's huge, man. You know, because a lot of times when you trying to build a channel or you're trying to build something, and then you have another project, and actually the Mailroom Network was was the first project. This was a little bit later, so the fact that you were able to just like come through and support, I really appreciate it. The importance of Jeremy Bartley mentioning the fact that Stamper was the lead investigator is because, again, we're going to look at this. We're going to look at this preliminary hearing. This motion to dismiss the indictment makes, hear me out, it makes sense from a legal lawyer perspective, because this preliminary hearing, the juice wasn't worth the squeeze when it comes to the cross-examination. And this is what Jeremy Bartley was trying to present. It's like, yo, in the preliminary hearing, you didn't have a lot of information to give me. Now all of a sudden you had a private meeting and you knew exactly what was going on a month after. like all of a sudden, you know what I'm saying? Like for real. This is a very interesting thing. I want us to go ahead and look at this preliminary hearing. We're gonna watch this together, and let's take a look at this, and let's see how we feel about this now that we're seeing it later. Now that we're seeing this later, let's see how we feel about this now. Okay.
Morgan District Court's now in session with the Honorable Rupert Billoy.
Thank you, sir. You may be seated. I'm going to call the case of Commonwealth versus Shawn Stines, 24F-147, on for preliminary hearing. Is the Commonwealth ready?
Yes, sir.
Is the defense ready?
Yes, sir.
All right, call your first witness.
Commonwealth's Clayton Stamper.
All right, Mr. Stamper, if you would. Raise your right hand for me. You swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
He is the lead investigator.
Thank you. You may be seated.
Clayton Stamper.
You say your name correctly?
Clayton Stamper,
And how you spell your name?
ClaytonStamper.
Bill, how are you employed?
I'm sorry.
How are you employed?
I'm a detective with the Kentucky State Police assigned to Post 13 Hazard.
How long have you been employed at capacity?
I've been with KSP a little over 24 years, detective since 2006.
And have you, in the performance of duties of the Post State Police, have you investigated the death of Kevin Mullins?
Yes, sir, I did.
And can you tell us on what date that was?
It was September 19th, 2024.
In investigation of that death, were you able to determine who killed Kevin Mullins?
Yes.
And how were you able to do that?
Video surveillance footage.
And did you retrieve that video surveillance footage?
I did.
You know, at this time, the company moved to play video footage.
All right.
Yes, approach the bench.
All right, so they took the time to approach because the video is graphic, and it is him showing what happened, and then after that, the family cries and things of that nature. So we're going to kind of skip past that part a little bit. All right, here we go.
15 seconds.
15 seconds. In fact, the video that was taken.
Let me come back a little bit.
That is,
That is the judge's chambers
and where's that located at, physically located?
in the Letcher County Courthouse.
That's all I have you on.
We'll slow this down a little bit because we really need to hear this.
That was a short clip that was played there. How long do you believe that clip was?
That we just watched.
Yes, sir.
Just 10 seconds, 15 seconds.
10, 15 seconds. In fact, the video that was taken in the judge's chambers between the meeting between Sheriff Stines and Judge Mullins, it's my understanding that video lasted much longer, correct?
Yes,
Okay. And have you had an opportunity to review the video
I have.
of the prior incident?
I have.
And can you describe for us what happened immediately prior to the clip that we saw?
Sheriff Stines uses his telephone to make some phone calls. He then borrows Judge Mullins' cell phone and appears to make a call on that. And that led to what you just saw.
Okay. So it's my understanding there were some people who were having a meeting with Judge Mullins prior to the sheriff's entry into the chambers. Is that correct?
Yes.
Have you identified those witnesses?
I don't know the names of them. There's about approximately 4 people in there. Then Sheriff Stines enters the judge's chambers and everybody else clears out.
You don't know their names?
Not right off, no.
Have you prepared a report?
In the process, yes.
You're in the process of preparing a report,
Yes, a lot of information.
but you've not spoken to any of those witnesses?
I've not directly, but they've all been interviewed. There's recorded interviews of those people in the case.
Okay, so other officers have spoken with those 4 witnesses?
Yes.
And what is your understanding of what those 4 witnesses have said?
I don't recall.
You have no idea what they said?
No.
I want to make sure I understand, had there been a hearing previously this day in chambers?
In the courtroom?
No, in chambers.
Not that I'm aware of.
Okay. And so there's a video camera that is running in the district judge's chambers. Is that on all the time?
It's my understanding, yes.
And have you spoken with anyone about why that may be?
No. I mean, there's cameras.
Dude, you mean to tell me, now you the lead investigator, right? You mean to tell me you are the Kentucky State Police, KSP. Now, to be fair, I know that he's not a part of Letcher County like that. He's a state officer. I get it. But even as a state officer, you mean to tell me you're not even curious about why there's a video camera inside the chambers of a judge? You're not even remotely concerned about that? I don't know, man. I don't know, man. It's kind of crazy.
Throughout the courthouse.
Well, fair enough, but are you familiar with district judges' chambers normally, how they're set up?
No, I mean, some of them have video surveillance and some don't.
Right.
This one does.
Generally, when they have surveillance, you agree with me that that is utilized when there is a proceeding going on in chambers, correct?
It could be, yes.
Okay. And I mean, I'm just asking, so this video didn't have an audio recording to it, correct?
There's no audio.
Outside of once the 4 people that were inside, that we don't know their names, once these 4 people had left the chambers, were they in an area adjacent where they could hear anything that was going on?
Yes, I believe some of them did remain in the next room.
Okay. And what did they tell us?
Do what?
What did they hear?
I've not been part, I wasn't part of those interviews.
Okay, so if I'm understanding correctly, you're prepared for a preliminary hearing on a murder, and there are witnesses in an adjacent room.
I mean, they heard
Can I put
gunshots.
my question, please?
Yeah, let me ask the question.
Thank you, officer. So you are investigating a murder and testifying in a preliminary hearing, and there are witnesses who may have overheard what preceded this edited clip, yet you can't tell us today anything that they said?
I've not personally listened to those interviews. I've talked to the other officers that did those interviews.
Fair enough. And I mean, we're here at a preliminary hearing, as you know, that you can testify to hearsay. I'm asking you what they said.
They heard gunshots.
Okay. Was there any statements that they overheard?
No.
Were there raised voices?
There, one person stated that she didn't recognize him as being Judge Mullins' voice, but heard somebody say, "Help, help."
Presumably that would be after the firearm was drawn or shot.
Objection, Your Honor.
I withdraw, Judge.
Withdrawn.
So is there any testimony that you can give us today about any statements or arguments or the content of that argument prior to the shooting?
No.
Okay. I want to ask generally, so did you process the scene? Are you the lead investigator on this case?
I am.
Okay, so as a lead investigator, I would presume that you would have secured the chambers and evidence once you arrived.
I was part of that, yes.
You were part of it, right? But you're the lead investigator, so you'd be in charge of those duties and delegating what should be done. Is that
No.
fair?
No, I don't delegate what's done.
Okay, so you're the lead investigator. What does that mean?
I'm the case officer.
Okay, so you're carrying the case. So I want to make sure I understand. Had Judge Mullins been removed from chambers when you arrived?
No,
Were you able to ascertain, did he have a firearm on his person?
we did not locate one.
You did not locate one?
No, there was not one in the chambers.
Okay. And there was none on his person?
No.
Okay. All right. Who was the first person to arrive on behalf of law enforcement to investigate?
They were already in the courthouse.
Fair enough, but I'm talking about in terms of people that we may see a report from or take part in this investigation. Who would be the first person?
I believe Trooper Jason Bates was the first KSP personnel on scene.
And you spoke with him,
I did.
and he searched and did not locate a firearm?
No, he didn't search the scene, no.
You
His
just-
role,
Sure.
his role at that point was security of the scene.
I understand, but I'm just trying to ascertain, you said earlier that there was no firearm found.
No.
I'm wanting to know, can you tell us, was it specifically searched for a firearm?
In the judge's chambers,
Yes, sir.
there was myself, Detective Chris Collins, Detective Scott Caldwell, Detective Eric Caldwell. That's all I recall right now.
Okay, but I'm trying to understand, so who searched specifically for a firearm?
We all did.
And that was specifically something you looked for?
Yes.
Fair enough, okay. of course, your investigation, did you ascertain that prior in the day there had been a lunch meeting between Sheriff Stines and Judge Mullins?
There was.
Pardon?
There was.
Okay. Sorry, I couldn't hear your response. I wasn't being trite. So where did this take place?
It's a restaurant called Street Side, and it's just down the street from the courthouse.
Okay. And it's my understanding there were a couple of other people who attended the luncheon?
There were several, yes.
Okay. And at some point after that, they wrapped up lunch and left, obviously, and went back to the courthouse. Are you aware of anything so far in your investigation that would tell us there was any issues at lunch between Judge
No.
Mullins and Sheriff Stines?
No.
Okay. But someone on behalf of the KSP has spoken to those witnesses?
Yes, they've all been interviewed.
And there was nothing unusual that had arisen during that luncheon?
I was told that the judge made a statement to Mickey about, do we need to meet private in my chambers? That's all I was told.
Do you know the context of
I do
what
not.
the conversation was before that they would need to discuss in chambers?
I do not.
So it's my understanding that in the larger portion of the video that we haven't had access to, that there is a point when Sheriff Stines asked for to see the telephone of Judge Mullins.
Yes.
Is that a yes?
Yes.
Yes, okay. And I would presume that you and the other officers you mentioned, when you secured the scene, that you secured those phones as well. Is that correct?
Yes.
And have you reviewed both of those phones?
They're currently at the forensic lab at this time being downloaded. I have had discussions with the people at the lab regarding the downloads.
And those are a couple of other questions that I was going to ask you, but my original question was, have you reviewed or are you aware of the content of the phones?
I've not personally seen it because I've not received those reports yet.
Okay, again, based upon your conversations with the officers, are you aware of any recent content that was up and could have been relevant at the time of their discussion?
I was told that Sheriff Stines had tried to call his daughter, and he had tried to call his daughter from the judge's phone also.
So, have you obtained the phone records from Judge Mullins' phone?
I don't have those in my possession yet, no.
Okay, have you issued a search warrant for them?
Yes.
Okay. And have officers confirmed that the sheriff's daughter's phone number was on Judge Mullins' phone?
Yes, I believe so, yes.
So that number had been called from Judge Mullins' phone?
Yes.
Is that correct?
Yes.
Okay. So we don't have a viewing of what transpired during that exchange of phones. But based upon your review of those moments prior to, when Sheriff Stines observes that cell phone, was he previously seated?
Yes.
Okay, so in the clip we saw him standing the entire time.
He was seated in front of the judge's desk.
And he looks at the cell phone. What is it? Can you describe his reaction in the video that we haven't seen?
Whose reaction?
Well, the sheriff.
You can't see his face in the video.
Okay. But is it clear that, does it appear to you that, let me rephrase this. Did he stand up after
Yes.
looking at the phone?
He stood up.
And how long after he looked at the cell phone and stood up did this occur that you played?
Just seconds.
Did you make the decision on edits today for for what you were going to present? In
Do
terms of, did you make the edit or determine
No,
which portion of the video we were going to see today?
No, sir, I did not.
Both cell phones have been sent to the Kentucky State Police Forensic.
Okay, I just want to stop right there and just say this. That was a good question because, again, we read the motion. We read the motion where he's saying that the Commonwealth chose to leave certain things out of this prior meeting, right? That never got recorded. Now he's in the preliminary. Now, see, we looking back to move forward. Now, looking back at this, he's asking him, well, did you edit this entire video? He like, no, I had nothing to do with it. So who edited it? Right? He didn't ask him that, but that's the question on the floor. Who did it? Obviously, it's the prosecution. So he's building a case of conspiracy against Mickey Stines. He's also building a case of insanity. He's also building a case of the fact that the indictment is not correct. He's already brewing, you know. So he's actually been rocking out with this idea way before this whole motion came to be. And I think because he was able to find something that wasn't right, now he's going to strike and attack way before they come up with a trial date. I don't even think the discovery is complete yet. I know the discovery was like 6 to 8 months. So from the last hearing that they had with the special judge. So I don't even think the actual discovery is done. But while it's going on, if the indictment isn't right, you can't try a case. You can't try a case with an indictment that's miscategorized. Otherwise, what you would be doing is practicing prosecutorial misconduct, and you would not win the case because you have to prove that this particular charge is associated with this particular evidence that you have. So when a lawyer is making their opening statement, a prosecutor is making their opening statement, everything that the person is charged with, they need to have evidence that fit that charge. If it doesn't, it can cause a mistrial, and no prosecutor wants a mistrial. None of them. This is the reason why Karen Reed's case is being retried, and they got a special prosecutor by the name of Hank Brennan, who's really a defense attorney. You know, he's famous for defending Whitey Bulger, who was a known mobster in Boston, right? I mean, well-known mobster. If you don't know anything about Whitey Bulger, just Google Whitey Bulger. You trust me, you're in for a treat with that one. All right. And Hank Brennan was on his defense team. So, you know, but he's a prosecutor. Now he also has prosecution experience as well. So that's how he cut his teeth. So you don't want a mistrial. So that means that the indictment has to be on point. So if anybody's ever going through something, remember that. Make sure that if they indict you with the wrong charge, with the wrong count, and you can refute it. I always tell people this: never plead guilty for something that you didn't do. Don't apologize for something you didn't do. You don't need to look guilty about something that you didn't do. So all of that matters. Your poise, your demeanor, all of that matters. When you trust me, I know what I'm talking about. I've been through some things. I've been on probation. I've been through the system. I know. You want to keep your poise. If you didn't do nothing, you didn't do nothing. So don't look like you did something. Then they're gonna think you did something. That's all. So let's get back to it. I'm sorry, but I wanted to mention that because Bartley, now that I'm hearing this again, because I haven't heard this hearing in a long time, in a while, since I actually did it in one of the videos previous. Now that I'm listening to this again, it's like, yo, he's been building this whole insanity thing, but he's been doing it in a way where he's definitely claiming that the Commonwealth is doing something that they shouldn't be doing, and he knows that there must be some type of conspiracy or some type of illegal stuff going on, and Mickey Stines told him everything. You could tell when a lawyer has full information from their client opposed to them not. Mickey Stines done told this man everything. The way he asking these questions, Mickey Stein spilled the beans for sure. Okay. And he probably got, as the case gets built, he probably has more that he's going to remember as the case goes on. So let's take a look. Let's continue.
Yes.
Team, is that correct?
Yes.
Have you gotten any early report on what was found?
No.
Were both phones still on the desk when you arrived?
The judge's phone was on the desk. Sheriff Stein's phone was on his person.
Okay, so are there photographs of, was the phone locked at that point, or was it still open?
With both of you asking about both of them, or?
Well, first let's talk about, that's fair. First, I'm talking about Judge Mullins, since it was the one that was still on the desk and presumably nobody touched it prior to you securing it, correct?
No.
So, yeah, so I would like to know about that. Have you ascertained what was currently open on that cell phone?
No, I don't know at this point, no.
You don't know?
No.
Do you think that will be important to learn?
I hope to learn that when the report's ready, yes.
Okay. But as of today, you can't tell us
No.
what was currently open on the judge's phone?
No, sir.
Right, Tracy. Your boy Bartley got info. He got info. He got insight.
Sheriff Stein's daughter.
I did not, but she has been interviewed.
Are you aware of who was present when she was interviewed?
Lieutenant Randy Combs and Detective Anthony Trotter.
She was interviewed with or without her parent?
With.
So her parent was present at the time you interviewed her?
Yes, I believe. I wasn't there, but yes, I think so.
And law enforcement has not spoken to her without her parent present?
Not that I'm aware of.
Did the Kentucky State Police obtain her phone?
No.
You intend?
Why not? Why not? You took the judge phone. You took Mickey phone, but you didn't take the daughter phone who was in the judge's phone? To take the deepest dive you can to figure out, to at least X out the daughter. You haven't even done that. Lead investigator, what are you doing? You haven't done anything. You haven't done no work. You haven't done any work. You never seen the first 48, bruh? You never seen the first 48? Sir, you got to do some work, man. You're not curious about any of this. This is the reason why, like, certain lead investigators in prosecution, Commonwealth. This is the reason why I made that video about prosecutorial misconduct on my channel. They are so lazy, man. Oh my God. They like, okay, well, we see it on video and that's it. And it's like, no, it's more to it. It's way more to it. You have not taken the daughter's phone at all. You have not done any, you didn't even think about doing any forensic data on her phone. This is what causes suspicion.
And to obtain records for her cell phone number?
Possibly, yes.
Do you believe that will be soon that you'll do that?
Could be, yes.
Had you already intended to do that?
Could be.
Did you just respond to my question?
Well, the call should be on the judge's records too.
Well, I understand.
And
but
she's made statements about what occurred during those conversations.
I understand that, but I would presume.
What if she's lying?
Have you ascertained whether Judge Mullins also had apps that stand outside of phone records?
I've not received those records yet. I don't know what's on the phone.
Fair enough, but I mean, did you look?
First of all, let me be real clear. This hearing happened like in October of 2024. So you had at least 3 to 4 weeks to ask questions about something. You have done nothing. You have not done anything. You got to at least exclude the idea of the daughter and judge. Yes, the judge, Mickey Stines, was able to call his daughter on a different phone, a grown man phone, a man who is a judge, a man who has a wife and kid himself, a man who has a whole family and community behind him. She is in his phone, and she picked up the phone when he called from the judge's phone. You can see Mickey Stines talking, even from the camera. You can see his demeanor change, and he starts talking. Then he hangs up, throw the phone at the judge, get up, and pull his gun out. And you didn't think that. What about text messages, sir? Huh? What about photos, images being sent or not being sent? Can you rule out that? Can you rule out the fact that maybe like it was like the conversations were actually just, basic conversations, whatever. Do something. You got the judge's phone. Great. You got Stein's phone. Fantastic. Why you have Stein's phone? Whatever. I have no idea. Well, for the group text, I know there's a group text message that they had. So stuff like that, sure. Right. You would probably try to incriminate him through a group text of guys who some good old boys down there who do foul stuff, and you want to see if Mickey is involved. Okay, sure. But in the deposition of Sabrina Atkins, and shout out to Sabrina Atkins, she already confirmed Mickey Stines ain't did none of that nasty stuff y'all talking about. At least she hasn't seen it. She named 2 names in her deposition: Ben Fields and Kevin Mullins, who is the district judge of Letcher County. She says she was involved with Ben Fields on that Fugazi. Then she said she saw a video of the judge doing his business with an inmate for the fact of getting that ankle monitor off of them so that way they can, they'll be straight. Sir, you mean to tell me that you didn't find the video camera in the judge chamber strange? You didn't find it strange that there was somewhat of a little spackle at this bar and grill right up the street that had to have a private meeting with the sheriff, the judge's sheriff of his county, and him, right? You didn't find it strange that the judge that Mickey Stines was able to actually call his daughter from the judge's phone, and she picked up the phone. It's well known that she picked up the phone. So you didn't think to grab her phone either for forensic data? Sir, you are a detective. Detect some shit, man. Like, what are you doing? Jeez, oh Pete.
Look at the phone. Did it appear there were apps on it?
I'm not the person that's qualified to look through the phone.
Okay, but you're familiar with cell phones. They can host other forms.
Oh, he nervous. He deflected.
What's the objection?
He's asked a question, I think, about 4 or 5 different ways. The detective repeatedly said he does not have a report with phones. He's not looking at the phone. He can't testify to that matter.
I'll let him ask the question, and what he can only testify what he has personal knowledge about.
Thank you, Judge.
Right.
So you're aware that phones can be used for apps such as Facebook?
Yes.
Okay. And that is not something that is captured by cell phone records. You would agree with me?
I agree.
Okay. So in light of that, although the records may be mutually the same between Judge Mullins' phone and the sheriff's daughter, do you believe that you could also ascertain other information from the cell phone app content?
Are you asking what apps are on the phone?
Yes. Well, that was my original question.
I don't know
thought you didn't know.
I've not received that report yet. I don't know what apps he had downloaded on the phone.
If he has social media.
Where have you been, detective? What the hell is going on with you? Where have you been? How come you're not talking to anybody? This is your case. This is your case, man. Jesus. Oh, jeez, oh, Pete, man. I can't with this guy. Now looking at this again later, now that I've read this motion and I'm looking at this hearing, I am so irritated with this detective right now. This lead investigator, I am so irritated with him. He is getting on, he is tap dancing on that little nerve in the back of my eye, like the back of my left eye right now. He just like really like that little tap dance. He's really tap dancing on it. Sir, this is your case. You don't know. You haven't been talking to anybody like, hey, what's going on with the forensics? Have you found anything? Can you give me anything like that? Can you give me what you got so far? You know, I really need to figure out what's going on. I never heard of a sheriff shooting a judge. Blah, blah. Like, there's no sense of urgency at all. You just lackadaisical from the Kentucky State Police, just coming on in and investigating something that has way more to do with just a man shooting another man, a sheriff shooting a judge. There is so much other stuff going on. You're not investigating anything, bruh. Oh, I'm sorry. I'm on the rant. You know, y'all know how I get. Those that are a part of the Biz Nation know how I am. All right. When something don't connect with me, it really bothers me a little bit. All right. I apologize. I'm sorry. For all those that are new, I apologize. Okay, let's go.
Media apps do you intend to?
That could lead to additional.
Let me go back a little bit.
No, I've not received that report yet. I don't know what apps he had downloaded on the phone.
If he has social media apps, do you intend to?
That could lead to additional search warrants, yes.
If you would, officer, please let me finish before you move forward, and I'll try to slow down a little bit as well, okay?
Sure.
Thank you, Chair. Have you determined whether there were any previous issues, personal or professional, between Sheriff Stines and Judge Mullins?
I've heard things.
What have you heard?
Just that this regarding the lawsuit that the Letcher County Sheriff's Office is currently involved with.
Okay. The lawsuit that involved ultimately a criminal conviction of a deputy for sexual behavior in the judge's chambers. Is that the one you're referring to?
Yes.
Okay, and the subject matter of that lawsuit, the chambers area, that's the same chambers in which this occurred, is that correct?
I'm not familiar with the details of that case that the lawsuit resulted from.
Okay.
You see what I'm saying? You see what I'm saying? He don't know nothing.
Are you aware of any criminal reports that Sheriff Stines had made of Judge Mullins prior to this day?
No.
I'm so sorry. This man is irritating the heebie-jeebie out your boy. I can't. Thank you. He's not familiar with. First of all, you know about a lawsuit because you start talking. He started talking. Okay, he the one started talking about this lawsuit, right? You're aware of a lawsuit concerning the deputy sheriff, Ben Fields, that's related to the man that's right here on this camera. His name was on the motion, on the lawsuit. So you mean to tell me I have a case where I see a man on camera who is law enforcement shoot a judge 8 times, close to point blank. Then I discover, because I'm Kentucky State Police, that he might not know. I'm trying to be fair. He might not know anything about Letcher County. So I'll give him that part. I'll give him just that part though. Okay. What I can't give him is his skill set. So you know that there's a lawsuit that is related to two men. The one that's already been faced with the charges and pled guilty. He pled guilty to everything. They're like third degree essay and all this other stuff. And then the man sitting in front of you right now is on the same lawsuit. You didn't think to like look at that and be like, you know what? Let me look at this lawsuit real quick. What's going on here? Where are they blaming him for? Oh, he didn't train his. Okay, cool. So that means him and Ben is cool. Okay, if they real close, I wonder if they talk to each other a lot. You know, I wonder what their relationship is like. You know, that's detecting. Your ass ain't doing nothing. you over here, you investigating biscuits, money. Like you ain't doing nothing, bro. Golly. Let's continue.
Prior to this day.
No.
Did you personally observe Sheriff Stines following this video?
Did I personally observe him? What?
Did you meet with him? Did you talk to him after?
He was in custody when I arrived at the courthouse that afternoon.
And at some point, did you draw any observation about his demeanor?
He was mostly calm, I thought. I mean, I talked to him, but he didn't say nothing about why this had happened. But he was calm.
He was not calm. You see, this is why y'all got to go back and look at my last live. That man was not calm. The man was paranoid in a mug. He said that if you take me to Leslie County Jail, I'm going to draw my last breath. That's what he said to the police, to their face. That man was not calm at all. I know I got a small audience tonight, and it's cool. I get it. It's all good. But put a 1 in the chat if you was rocking with me the last time we saw the extra footage where this man sat down in front of Mickey Stines, and Mickey Stines is like talking about how they gonna unalive him. And he's like, why do you think we gonna hurt you? Why do you think we gonna hurt you? I also have body cam footage of the time where he went to the Sally Port. I got that. Go to the Shawn Mickey Stines playlist on this channel. You will see body cam footage. You will see extra stuff. He was not calm. This man is lying. See, now he's lying. See, this is the reason why. This is the reason why you got to know your law. First of all, I recommend everybody getting the Black's Law Dictionary. Get it. It costs a little penny, but go ahead and get it, and get the Federal Rules of Evidence. Get that, and also get the FBI book about how to conduct yourself on a crime scene. There are 3 books that I think you should get. I'm telling you, this man is clearly lying, because when we on this channel, when we looked at new body cam footage, and if Ahmad can go to the channel. I think it's called new body cam footage or something that I named it, and it had an alarm on it. If you look at that video, you will see extended amount of camera footage from the chambers. You will also see the extended amount of body cam footage from the Kentucky Police Department, the Kentucky Police talking to Mickey Stines. The man had his shoes off. The man was paranoid. The man thought they was going to do something to him. As a matter of fact, he didn't even want to go down the stairwells towards the back of the courthouse. He didn't even want to go down there because he was like, "No, what y'all doing? Yeah, I don't want to go down there. Yeah, come on, guys, be fair to me. Be fair to me. Don't shoot me. Don't do this. Don't do that." That's not calm, sir. Oh, sorry, another rant. I apologize again. Oh. But he lying. He lying, man. This guy is lying. he calm. No way, no how was this man. Thank you. Please look at, he begged, please do me right, fellas. He begged. And he said, oh, he was calm. No, he was not. He was fidgety. His leg was going up and down. He didn't have his shoes on and all that kind of stuff. They had to help him with his shoes. The man was frantic, not calm.
To him, but not, he didn't say nothing about why this had happened, but he was calm. He was kind of afraid that basically all he said was, treat me fair.
What?
That's
What?
basically the comments he made.
Bro, what are you talking about? What are you talking about, man?
Statement about, I didn't see it in the citation. You're somewhere along the line, I saw a statement being attributed to him about protecting his family.
I wasn't present, but when he was taken into custody, I was told by one of the other officers that were there that he made the comment, they're trying to kidnap my wife and kid.
Okay, so how do you say that calmly? You literally just contradicted yourself, bro. You the one said that when you walked on the scene, he was calm. Now you said the statement that this man made was, they're trying to kidnap my family, or they're trying to kill my family. How was that calm, bro? Like, that was calm too. They're trying to kidnap my family. No man says that about his family that he's defending. Pack this dude up, man. Pack him up. Take him down to the airport. Put him on the flight on the Emirates to Dubai and let him chill over there somewhere. You out of pocket, bro. Pack this dude up, man. Now I see why they following this motion. We got to look at it on both ends. Now I see why the defense filed this motion. Pack this dude up. That's the face of a man that ain't slept. Gee, look at his face. Do he look like he's well rested and refreshed? Seems like they are still. Shout out to Miss DB in the building. Miss DB, shout out to you. I appreciate you rocking with your boy, okay? I definitely appreciate it. Seems like they are still trying to cover up something. So I'm glad we read that motion about dismissing the indictment, because this preliminary hearing is showing the opposite of that. Totally showing the opposite of that. I totally agree.
Now, have you ascertained any evidence that this shooting was pre-planned?
No, not at this time.
And would you agree that from what we've seen so far, from the evidence you've seen so far, the shooting was a reaction to what was on that cell phone in that moment? Is that accurate?
Objection, Your Honor. Also speculation outside of his self-expression.
He's the lead investigator.
If he
Whoa. He's the lead investigator. How is it outside of his scope? He's the lead investigator. Oh. It's well within his scope since he's investigating this entire case, dog. To say that this is out of his scope, what? He's a detective. This is what he do. This is what he should be doing. This is what he does. This is what he does. Now all of a sudden it's out of his scope.
Sure, I believe that if he has formed an opinion about the investigation up to this point, especially at a preliminary hearing, we can speculate on that, Judge.
Or sustain.
Sure. So, is there anything other than the content of the phone that this video will reveal to us about why this took place?
No.
Does it appear that this took place as a reaction to what was happening in the chambers at that point?
I can say it occurred after a phone call was made. I don't know what was said or nothing like that. But
Fair enough, and I'm not asking you the content of any of that, but at this point, is it your theory that whatever that content was in the discussion was the impetus of the shooting?
it could be, but I don't know that for a fact.
Okay.
Oh my
Do you have
God,
any
bro.
evidence up until this point that you have developed that would demonstrate that it was not as a reaction to what was on the phone?
No.
None whatsoever?
No.
Okay. Here's if I had just one moment to control.
All right. Okay, here we go.
Did you attempt to speak to Sheriff Stines at the Leslie County Jail after the incident?
No.
Good
Did
question.
anyone from your agency attempt to interview him?
Not to my knowledge, no.
Oh,
A bullshit. A bullshit. A bullshit. A bullshit. A bullshit.
really? Bruh. The guy who did, you didn't think to ask, you haven't talked to Mickey Stines since the incident? Yeah, pack this dude. I'm done with him.
And
He
at
the
that
worst
point, had he
detective ever.
asserted his
Inspector Gadget was way better than this, okay? Inspector Gadget was way better than this. Way better. Stamper, pack this guy up. You hear me? Pack him up. Pack him up. Inspector Gadget will run circles on this dude. I'm telling you. Inspector Gadget would have the case done in a half hour because the show only lasted for a half hour. He figured it out. He'd get that helicopter out of his hat, fly over to the jail, figure out what's going on with my man Stines, come right back, boo-doo-doo-doo-doo, boop, boop, credits. Then you see the credits of the show. He done solved the case right in front of you. You didn't even know what happened. Inspector Gadget was a G. You didn't even know what happened because he closed cases quick. This dude, this guy here, no. He is a dud. He is a dud. Why wouldn't you talk to Mickey? He's a fellow law enforcement officer. He the first person you should investigate, bro. You should have got an interview with him ASAP. This guy, pack this guy all the way up.
Right to an attorney or anything?
No,
He asserted to interview him.
not to my knowledge, no.
And at that point, had he asserted his right to an attorney or anything?
No,
But nobody went back to try to talk to him or do an interview?
no.
Okay. I think I have one other question. In addition to cell phones that we discussed, the cell phone of Sheriff Stines and the cell phone that you found of Judge Mullins, were there additional phones that you were able to obtain?
There was one other phone that's currently being examined, and the basic reason it was seized was there was a text conversation between Sheriff Stines and some of his employees with the sheriff's office.
See?
Okay, and that was
I knew it.
an additional phone of Sheriff Stines.
It was a phone of, I guess she's the, I don't know what her title is, but she's employed. She's not sworn. She's employed by the Letcher County Sheriff's Office. And she voluntarily gave her phone to the person that interviewed her.
Okay, and just out of curiosity, could you explain why that was relevant or germane to your investigation?
I didn't conduct that interview, but it was, I guess it was regarding the dinner at Streetside and things that led up to the shooting. But I don't have those results either, so I don't know exactly what was said.
Correct me if I'm wrong. I thought when we discussed that earlier that you indicated there was no evidence that the conversations at the lunch.
I haven't seen those conversations yet. I've not received the downloads from the phone.
Right, but I asked you if you're aware of any information that could have been gleaned from witnesses at that meeting, and as I recall, you said no, but there is some information that something was discussed at this lunch. Is that correct?
I don't know what was discussed at lunch.
I understand, but you obtained this lady that we don't know her name, you obtained her phone in an effort or based on a belief that she would be able to demonstrate what was said at lunch. So you would agree with me, you believe that there is a witness or information that may have popped up at lunch.
There's a recorded interview with her in the case, and I'm yet to receive the downloads of the phone, so I don't know what they contain.
Okay, has that phone been sent to the forensic examination as well?
Yes.
All right, thank you. Also, that's all I have. Thank you.
Redirect. Questions. Has Judge Mullins, he sent to medical examiner's office for autopsy?
He was.
Have you received that report yet?
No.
Have you had an informal conversation with him regarding his cause of death?
Yes.
And what was that?
Multiple gunshot wounds.
The video we showed earlier, that a true and accurate clip copy of what you received?
Yes.
Councilman introduce Council Exhibit number 1, Your Honor.
Any objection?
Your Honor, I'd ask, of course, all we saw today was the clip, but I asked it be admitted in its entirety, Your Honor.
You want to respond to that?
Did not only think preliminary hearings required, of course, probable cause. This statute of probable cause, I think the entire clip is outside the purview of these proceedings.
Yeah, I think if you're going to want to see the whole video, you should have objected earlier. I'll admit the short clip. Yeah.
Wow.
I have the clerk.
So since they allowed the short clip already, they're going to continue with it and be like, well, you should have asked for the whole thing earlier, but you didn't, so whatever. It's crazy.
Enter that as exhibit number 1.
And Detective, this is an ongoing investigation.
Yes, it is.
And as this ongoing investigation proceeds, you will be obviously interviewing more people if necessary, submitting more evidence to the lab.
Yes.
That's all I have, Your Honor.
Recross. All right, any other witnesses for the Commonwealth?
No, Your
All right, you may sit down. Any witnesses for the defendant? I'll find probable cause and bind this case over the grand jury. Anything else?
All right. So that was it. Basically, that was the preliminary hearing. My God, I gotta get some water. It's absolutely insane. So the grand jury, this is October. What happened? What we're looking at now. Then the grand jury indictment was November the 21st, right? 2024. And that particular hearing, apparently, Stamper had a lot more to say. Right, a lot more to say. Didn't have much to say here a month after the shooting. Right. So the investigation, the initial investigation here is pretty weak. However, again, to be fair, he is not a part of Letcher County like that, right? So he did, like, when you look at the body cam footage, he didn't even know like where things were in the building, like what led to what, not where the Sally port was, how you get to it. Like he didn't know it to a T like that. You know what I'm saying? The reason why the other gentleman knew where it was at, because they frequently visit there, because they're good old boys. They all grew up there. They all, they all from Letcher. But in this particular case here, the problem with this is the fact that, and let me know if you agree with me or not. The problem with this is the fact that you have a detective, you have a lead investigator who is not leading the investigation, apparently, because he said something on the stand that was kind of weird. Like, he was like, well, I didn't conduct those interviews. Well, who else is investigating this besides you? If you're the lead, who else are you talking to? Who's under you? You're the lead, and then you should have people that follow you, right? Okay, are they telling you anything, bro? They're not telling you nothing. If you're the leader, that means you have followers. Otherwise, you're just an individual. If I am leading in the investigation, that means I have people following my lead, which means they should report to me. And if they conducted an interview, they need to tell me, because I'm the lead investigator and I'm the one that have to be on the stand to say something. That right there lets me know that he's not leading this investigation. He ran into those we'll take it from here people. Oh, that's what he did. He ran into some we'll take it from here. You're just going to be, to me, it seems like Detective Stamper is more of a scapegoat than an actual participant of this case. Because for him to say that Mickey Stines was in his sane mind when he got there is absolutely fallible. It's the most fallible thing he said on the stand. It is fallible at best. There is absolutely no way you, an investigator from the Kentucky State Police Department, who's not really familiar with Letcher County like that, according to him, okay, there is no way you walking up on that scene and then you would look at Mickey Stines and be like, you know what? He look like he in his right mind. That man was not in his right mind. We have the evidence to prove that the man went in his right mind. He thought they were going to unalive him. Even we have the body cam footage when he was in the car on the way to the jail on this channel. And in that vehicle, when he was like, hey man, y'all making the wrong turn. Come on, guys. Don't do this to me. Come on, be fair to me. Be fair to me. Be fair to me. The man thought they went down a certain path that they normally don't go down, and that man thought they was about to detour somewhere else and just like assassination style and just come on back. And the driver, who's familiar with Mickey, kept asking, "Is this got something to do with your family? Is it got something to do with your daughter?" He kept asking him questions, and Mickey wasn't answering none of those questions. So to say that this man was calm is fallible. Like, you don't know how to investigate a case, bro. Something wrong with you. Let me tell you something. I could get the nosiest black woman from Detroit to solve this case. Okay. Oh, I could get one of them aunties that be in everybody's business at the cookout. Oh, she will lead this investigation and solve the case immediately. Immediately. Yes. Yeah, Auntie Pam, Aunt May, okay, Aunt Cora. Oh, this case is over. They done talked to the man who shot the judge. They done talked to his wife. They done talked to the dog. They talked to the old dog's owner. They done talked to the man that was that was riding with him all day. They talked to him. They done talked to everybody. They done talked to everybody. Shout out to you, Tracy. I appreciate you rocking with me. They done talked to everybody. She said, Miss DB said, like me. Miss D, Aunt D. Like, they done talked to Aunt D. Everybody. Aunt D done did it. It's over. So the fact that you haven't even done just basic common sense investigation, retrieving the phones, collecting evidence is one thing, but you're the lead investigator. You need to investigate this whole thing. Yo, man, this is crazy. This is absolutely crazy. I wanted to go ahead again. Thank you so much for rocking with your boy tonight. I definitely appreciate you. It's Friday Eve. It's my mom's birthday. She turned 74 today. Shout out to moms once again. And I'm telling you, man, like, this whole thing is just, this whole case is wild, man. Now, I will be keeping my ear to the ground because I know that the Commonwealth is going to respond to this motion. Of course, they're going to mention the fact that this whole thing is on video camera, that it's undeniable, and the defense is trying to reach and find something that ain't there, and blah 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 blah, do all that whole thing. So we know a motion is coming soon. I'm gonna keep my ear to the ground and definitely make sure that I, catch this motion that comes about. Again, the response to the motion. Again, go ahead and like, share, and subscribe to the channel, man. If you all want me to just, I have a range of things I'd like to talk about. Of course, I'm investigating this Mickey Stines case, but I'm definitely also into the realm of just like good conversation, good, healthy conversation, man. If you have anything, any reaction videos or anything you would like to suggest to your boy where you want us to like deep dive into stuff, go ahead and email me at taybiztv@gmail.com. taybiztv@gmail.com. Hit me up for any content suggestions or reaction videos you would like. I'll be more than happy to oblige or to accommodate. You know what I'm saying? I got some stuff I got to do when it comes to this particular case. I'm going to deep dive into the ARC case, the ARC fraud, the Medicaid fraud that has a lot to do and it's a lot of connection with Letcher County with this as well. I'm telling you, once I gather all this stuff and I get it going, I'm gonna definitely drop the video. So stay tuned for that. But I appreciate all of you coming through. I appreciate the mods. I appreciate Miss DB in the building. I appreciate some other people that came in and dropped off and all that kind of stuff. I appreciate you as well. Yo, Abundance, I appreciate you as well. Always, every day, all day. Abundance, again, like I said, Abundance rock out with your boy, man. Because even with the Mailroom Network, she rock out with the Mailroom Network, which is another channel that I'm on, but I'm on there with my brothers. We do this as a shared effort. So I definitely appreciate it. Yo, I am done for the day. So way to crack it up. You got at least exclude evidence. Oh yeah, I am done for the day. I'm definitely want to make sure, shout out to Miss DB again. Thank you. I appreciate you. We are definitely going to go ahead and call it a night. Yo, hope you all, I know the NBA Finals is on. Thunder versus Indiana Pacers. I hope if you watch it, cool. If not, I understand. You know, it is what it is. But I hope everybody have a good night, have a safe night as well. And I'll holler at y'all next time. Peace. It's your boy Tay Biz. Much love.
No stress, no biggie. Baby, I'm just too jiggy. Better know I brought that with me. Case they get too iffy. Baby, don't stress, don't sweat it. Put it all on my daddy. Know how I'm coming. And they know what we hate. Around through that left side, low end. All of mine need more wins. If you got beef, don't come out. My young hitter might go in. Uptown, GN. Working all through my weekend. Hoping these don't show out. Cause all of my hitters too deep in. With the boy, I'm so seen. Ain't worried about long as my money and my green. Baby, I ain't got work tomorrow. Tell me what the business is. Ain't about no club hop. I'm trying to start some businesses. Shorty, you thought it was, they better know it's not that. Talking all that online, they knowing that it's not fake. Sliding through my hood, I make maneuvers like a Uber, baby. Got a 10-year plan, these can't tell what they doing lately. And I'm way too clean, I'm Listerine, I thought they been knew it. All in my lungs, I got my red cup full of that hand fluid. Young middle Mad Mac, I'm swinging that leg, I'm banging that do or die. And I ain't that bleedly before I get crucified. Living in my bloodline, this place in my family tree. How the they pressed, I did my best out of what they handed me. Straight out of that country, know my shawty thick as human air. And I need not mention no extensions, that's human hair. Boy, we grew in there. Around through that left side, low end. All of mine need more wins. If you got beef, don't